So, Bury Metropolitan Borough Council versus SU 2010. When considering a child's right to be educated in a mainstream setting under a statement, now an EHCP plan, the question of whether mainstream education is suitable is not in itself the determining factor. The key issue is whether a placement in a mainstream setting would be incompatible with the efficient education of other children, and if so, whether that incompatibility can be addressed through all reasonable steps. So, every child has a right to a mainstream education. So what they're saying is, when we're looking at incompatibility, etc., what we're actually looking at is whether it would be incompatible with effective education of others, and whether there's any reasonable steps that could be taken to alleviate that incompatibility. So is it that we need more staff? Is it that the resources will be stretched thin and we need more resources? Is it something that can simply be solved by buying something in, bringing more staff in? What it would be anything that is not solvable would be more like the bricks and mortar, the area in the room. That would not be reasonable. It wouldn't be reasonable to need to build another classroom or an extra space, etc. That kind of stuff. ME versus London Borough of Southwark. In considering a child's rights to a mainstream education under a statement, now the I don't know why that one's there twice as well. Oh well. So that one's not right. It's this one. Harrow Council versus AM. When a parent requests a mainstream school and no suitable placement is available, whether within or outside the school authority's area, the local authority has a duty to make a mainstream school suitable to meet the child's needs. This duty is subject only to the requirement that the placement must be compatible with the effective education of the other children. So a mainstream school can be altered to meet the child's needs, but it cannot if it would then mean that it'd be wouldn't be compatible for the education of others. So you can't change a whole placement for one child and the other children not work. But if it's possible to change the placement or something within the placement to suit the child and it works with the other children, therefore that would be a suitable reason and reasonable steps taken to ensure that child can attend a mainstream education. So AA versus London Borough Onslow 25. This case highlights that many mainstream schools, including those with attached resource bases or units, remain mainstream schools, even where they provide specialist provision for some pupils with special educational needs in separate classes. A local authority meets its duty to name a mainstream school where a parent seeks mainstream education if it names such a school in the HCP plan, including one with a resource base or unit. Section 33 of the Children and Families Act 2014 does not confer a right to a specific mainstream setting or to a particular mainstream experience. So if you ask for a mainstream setting because you're looking for a resource base, if that the local authority put them into that mainstream setting, then they could put them in the base, or if the base doesn't have any spaces, they could put them in the mainstream school and they're still meeting that duty. If you want your child to go to a mainstream setting and you don't want them in a unit, but the school has a unit and the LA do put them in the unit, that would still be classed as the child having access to a mainstream setting or being in a mainstream setting, because you can't necessarily pick and choose whether it's the unit or the mainstream setting.